client, yeah.
And then, let's see, what's the next case that you were going to talk about? Kacavisti v. Sprague Electric, 102 New Hampshire, 266. Actually, that was a 1959 case.
1959. Here again, I just point out that hardly any women were involved in arguing any cases in 1959, so I thought, you know, these things were really an opportunity. But if the case presented some unusual issues, you know, I was particularly interested in, or something that might have some portent for the future. And this Kacavisti case, she worked, I think, at Sprague Electric Company, and she did some little operation, which I think probably, and people do so much now, but some little thing like cleaning wires with a little brush and using her thumb and squeezing, and she did that same little operation with the thumb, you know, 8 hours a day, and finally ended up with carpal tunnel syndrome, which was kind of even perhaps a new term in those days too. And the insurance company said wouldn't provide any coverage. They said, well, that's not, you have to give coverage, it has to be an accidental injury arising in and out of the course of your employment. And their contention was, well, she used that thumb, she intended to use that thumb, so it was not accidental. And there was a split in the country at that time as to whether that would be considered accidental, what something that you did, you know, intended to do. But here again, the Supreme Court went along with our side and found that that was accidental in it, arising in and out of the course of employment. And thereafter, every case, and there's a lot of carpal syndrome cases, that sort of settled the law. So that was in that area.
That was the first one in New Hampshire.
Yeah, I think that was the first one that said that was an accidental injury, that even though you did some intentional act. So that was, you know, you like to win them.